We'll continue with the processing of individual petitions, now at the level of the Human Rights Court. As we said, if the state against whom the petition is filed had granted jurisdiction to the Inter-American Court, the petition may continue and end up with a binding judgment. Before continuing with that procedure, we may check some statistics to see how many possibilities a person has to reach the court. Actually, there are not many chances to do so. In 2020, the Commission received almost 2,500 petitions, and only 23 cases were sent to the court. This shows that only 1% of cases are presented to the court, and this percentage tends to be more or less constant across time. On the other hand, it is important to note that the Commission is becoming less and less able to process all the petitions it receives. In fact, between the years 2015 and 2020, while the number of petitions is increasing reasonably, the number of cases at the merits phase has almost tripled. By the end of 2020, the Commission had approximately 1,400 cases on the merits, which is really concerning because the Commission usually decides around 20 and 40 cases on the merits per year. This means that each year there is a backlog of cases that will probably not result in a decision on the merits in the foreseeable future, which allows the court to engage in practice in some kind of docket control. Now, going back to the procedure, the Commission will send a case to the Inter-American Court when the state fails to follow the Commission's recommendations. Before the court, once we are before the court, there will be three parties: the Commission, the state, and the representatives of the victims. If the victims have no representative, the court will appoint an Inter-American defender. The representatives of the victims are very important because they may claim that the state violated more rights than the ones that were found by the Commission. They can do so as long as these violations are based on the facts that the Commission found. For instance, it could happen that the case was about an extrajudicial execution and the Commission only found that there had been a violation of the right to life. However, the representatives may also claim a violation of the victim's right to freedom of expression because the victim was killed because he or she used to write regularly on a newspaper, and that was the reason for his or her murder. The procedure before the court has two phases, a written and an oral phase. The written phase is the most important because here the parties will make their allegations and lodge most of their evidence. By the way, it is important to note that cases before the Inter-American system have a significant presentation and evaluation of evidence, because even though the Inter-American Court has a subsidiary role, it does not rely much on the evidentiary proceedings of the domestic judiciaries. The oral phase is made by a hearing in Costa Rica, where the parties present before the judges of the court their case and a very small part of the evidence, mostly the declaration of the victim and some other witness or expert witness. If a victim has no financial resources to fly to Costa Rica or to ask an expert witness to attend the hearing, the court may grant some resources taken from the Legal Assistance Fund, which should be recovered if the state is condemned. After this hearing, the parties shall make their final written submission and lodge the evidence that the judges may have requested during the hearing, and then the court will issue its judgment. It is important to note that the Secretariat of the court has a proposal to make to the judges even before the hearing. This happens because most of the process and most of the evidence is issued in the written form. Then, even though the Secretariat has made this proposal, the judges may follow a different path, which often happens. When the state is considered responsible, which actually happens 98% of the cases, the court will determine that the state has to make some reparations. And these reparations are actually very original at the Inter-American system, and that is why we will talk about them in our next section.